Visit our Swat&Vee channel with your questions to see how best we can help you out your process. Please don't forget to subscribe if you're new to the channel.
In this video, we are going to let you know some recent updates on U.S. immigration. Let's get into the video. Update number 1. U.S. Court rejects challenge to Biden's immigration policy. The U.S. Supreme Court, in a victory for the Joe Biden administration on Friday, upheld the federal government's right to decide which undocumented migrants should be targeted for deportation. In an 8-1 vote, the nation's highest court ruled that the states of Texas and Louisiana lacked the legal standing to challenge the federal government's policy. Texas and Louisiana filed suit after the Department of Homeland Security in September 2021 instructed U.S. Immigration and Customs Enforcement to concentrate expulsion efforts on persons who pose a threat to national security, public safety, and border security. Defending the policy of President Joe Biden's administration in court, Solicitor General Elizabeth Prelogar said the federal government has to prioritize its efforts because it does not have the resources to pursue the 11 million undocumented non-citizens in the country. Justice Brett Kavanaugh, who wrote the majority opinion, said the states had brought an extraordinarily unusual lawsuit. They want a federal court to order the executive branch to alter its arrest policies so as to make more arrests, Kavanaugh said. He said if the court ruled in favor of the states, it would lead to expansive judicial direction of the department's arrest policies. We could anticipate complaints in future years about alleged executive branch under-enforcement of any similarly worded laws, whether they be drug laws, gun laws, obstruction of justice laws, or the like, Kavanaugh said. During oral arguments before the court in November, Texas Solicitor General Judd Stone said prioritizing certain categories of persons for expulsion would impose costs on the state, which shares a border with Mexico, and is an entry point for hundreds of thousands of undocumented migrants every year. Texas suffers injuries regardless of what it does, whether it detains, releases, or paroles individuals because we have not only law enforcement costs, but social services costs and very serious threats of recidivism, Stone said. Greg Abbott, the Republican governor of Texas, denounced the court's decision as outrageous. Abbott, who has been sending busloads of immigrants to Democratic-ruled states in recent months to protest the federal government's immigration policies, said the ruling gives the Biden administration carte blanche to avoid accountability for abandoning enforcement of immigration laws. But the American Civil Liberties Union, on the other hand, said the decision soundly rejects the misguided attempt by Texas and Louisiana to force the government to implement the most draconian immigration enforcement policy. The Biden administration's move to target individuals considered a threat to national security or public safety for deportation represented a shift from the policy of the administration of former President Donald Trump, which called for the expulsion of all removable aliens. The Biden policy was immediately challenged by several Republican-led states as being too narrow and was blocked by a court in Texas before reaching the Supreme Court. Update number 2. The Biden administration says new immigration policy has slashed the number of migrants who can claim asylum at the border. The Biden administration's new immigration policy has drastically reduced the number of migrants allowed to apply for asylum at the southern border, according to a recent court filing by the administration, sparking backlash from advocates. Since the start of what is known as asylum ineligibility, only 46% of single adult migrants who have crossed the southern border have been allowed to claim asylum, compared to 83% from 2014 to 2019, according to the court filing. In a lawsuit brought by immigration advocates, led by the American Civil Liberties Union, the Biden administration argued that if the court blocked its asylum policy, the number of border crossings could rise to record highs, overwhelming border communities, and potentially pushing the Department of Homeland Security to release migrants without court dates to avoid overcrowding. In a court filing Friday, Blas Nunes Neto, DHS Assistant Secretary of Border and Immigration Policy, said, "The rule's implementation has generated widespread understanding that DHS has strengthened consequences at the border for those who enter without authorization, even as DHS has significantly increased lawful pathways and processes for non-citizens to come to the United States in a safe and orderly manner. The effect of these developments is that there has been an immediate reduction in encounters at the border," Nunes-Neto said. The Los Angeles Times was first to report on the Nunes-Neto filing Tuesday. Since the pandemic-era policy known as Title 42 was lifted last month, DHS has allowed migrants to be screened for asylum if only they can prove that they previously tried to apply for asylum in countries they passed through or that their cases are exceptions to the rule. Exceptions are made for particularly vulnerable populations, including people who may be victims of torture if they are blocked. Since the end of Title 42, border crossings have fallen from over 10,000 a day to roughly 3,500 a day, according to Customs and Border Protection. Update number 3. USCIS issues guidance on compelling circumstances, EADs. The U.S. Citizenship and Immigration Services has issued helpful guidance on how to apply for employment authorization documents based on compelling circumstances. When a foreign national applies to adjust status to become a permanent resident, he or she also has the option of applying for employment authorization. However, the adjustment of status application can be filed only if the individual's priority date has been reached. For individuals born in India, China, and a few other countries, there is a long wait. For example, for persons born in India, the wait is currently more than 10 years in the advanced degree and bachelor's and skilled level categories. Without the ability to apply to adjust status, the foreign national is at risk, particularly if subject to a layoff from an H-1B job. Unless the foreign national in these circumstances finds a new job or a new status, he or she will have to leave the United States within 60 days, or before the end of the current authorized stay, whichever period is shorter. Needless to say, this also hurts employers. In an attempt to resolve this problem, the USCIS in 2017 established a compelling circumstances category for the filing of initial and renewal applications for EADs. If compelling circumstances apply, the foreign national can remain in the United States while the application is pending, and for the period of employment authorized by the EAD. Unfortunately, there are unreasonable delays at the EAD application stage as well. Depending on which service center is processing the application, it can take 5 to almost 15 months for approval of an EAD. Meanwhile, the foreign nationals cannot be employed in the United States. The new guidance issued by the USCIS on compelling circumstances, EADs, provides helpful information that may mitigate the delays somewhat. Let's know, who is eligible for a compelling circumstances EAD? The principal beneficiary of an approved Form 1-140, immigrant petition for alien workers, in either the first, second, or third employment-based preference category. An individual who is in valid E3, H-1B, H-1B1, O-1, or L-1 non-immigrant status or authorized grace period when the Form I-765 is filed. Anyone whom the USCIS in its discretion determines demonstrates compelling circumstances that justify issuance of employment authorization. In addition, the following conditions apply. The principal applicant must not have filed an adjustment of status application. An immigrant visa must not be available to the principal applicant based on the applicant's priority date according to the relevant final action date in the U.S. Department of State's Visa Bulletin, in effect when the Form I-765 is filed. The applicant and dependents must provide biometrics as required. The applicant and dependents must not have been convicted of a felony or 2 or more misdemeanors. The guidance indicates that compelling circumstances can include serious illness and disability, employer dispute or retaliation, other substantial harm to the applicant, or significant disruption to the employer. The applicant may submit with the I-795 application proof that he or she has lived in the United States for a significant amount of time, such as school or higher education enrollment records, mortgage records, or long-term lease records. Compelling circumstances also could include if, due to job loss, the family may otherwise be forced to sell their home for a loss, pull their children out of school, and relocate to their home country.
I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit that thumbs icon. Thanks for watching. And don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!